Hi, my name is François. I made this video in the course of the IP management that I teach at the French-speaking Catholic University of Louvain in Belgium. This is part of a series of a video dedicated to COVID-19 and IP. In a few months, there will be a lot of IP discussion when we have a cure or vaccine against COVID-19. At such time, the question will be, how can we make sure that everyone on Earth who needs the medicine or the vaccine has an access to it at a reasonable price? It will be probably a huge and perhaps bloody fight, especially for less developed countries, but not only for them, probably. To understand the debate, you need to know the architecture of IP and free trade. In this video, I will explain the general principle of the IP rules in a globalized world. These principles are embedded in the TRIPS agreement. Next week, I will come with another video explaining how the TRIPS agreement provides mechanisms to secure the accessibility of medicine and vaccine. These mechanisms are called flexibilities. But first, let's make a bit of history and go back to the 19th century. Have a beautiful day. I would like to shortly make a brief history of the TRIPS and the Paris Convention to let you understand how things have evolved in these international treaties. We have two main treaties. The first one dates back to 1983, which is the Paris Convention. This is the first time that there was some set of rules applicable to a union between different countries. Then we have in 1947 the signature of the General Agreement on Tariff and Trade, that is known under GATT name, which is focused on the reduction of tariffs and trade barriers. As such, the GATT agreement does not talk about IP. After the GATT, there were a lot of rounds of negotiation to modify the applicable rules to international trade. And one of these rounds, that is called Uruguay round, gave birth in 1986 at the creation of the World Trade Organization, and exactly at the same time to an agreement that is called Agreement on Trade-Related Aspect of Intellectual Property Rights, which is TRIPS. TRIPS is the result of a huge fight between developed countries and developing countries. Finally, US and EU won to consider that IP was part of international trade. Today, when a country wants to become part of the World Trade Organization, he must absolutely adhere to the TRIPS agreement. There were other discussions, but the TRIPS agreement have evolved, pushed by least developed countries facing huge and important health issues and crises like HIV. And then came at Doha in 2001 a declaration on the TRIPS and public health. Then in 2003, a decision or an amendment introducing an Article 31 bis to the TRIPS concerning the import of medicines in case of compulsory license. I mention the Doha Declaration and the amendment on Article 31 bis because they play a very important role in the accessibility to medicine at an affordable price, which is the subject of the 3 lessons that we are studying now. I propose you to look at the Paris Convention in a nutshell. The Paris Convention was signed at the end of the 19th century in 1883. It is the first comprehensive international treaty in IP. It has been amended a few times, but the convention is frozen since 1959 because future amendment to IP law at an international level will be done through the TRIPS agreement that we're going to talk about later in the lesson. I would like to focus on one of the main achievements of the Paris Convention. The Paris Convention creates a union for the protection of industrial property. It is said in Article 1. Who are the beneficiaries of this union? There are 2 types of people who benefit from the union. The first category is national of any country of the union, so it's based on the nationality. And then a second category in Article 3 is national of countries outside the union but who are domiciled or have a real and effective industrial establishment in the territory. So you can benefit from the rules of the union through 2 different ways. The first one is to be a national of the union, and the second one is to have an effective establishment in the union. The Paris Convention is applicable to a lot of IP, but mainly for patents and also for trademarks. Today, we are going to discuss and look only on patents. The first thing to mention is the definition of industrial property. And Article 1 explains that industrial property shall be understood in the broadest sense. It means that anything technical can be considered as industrial property, and you have a few examples that show that it's not only limited to industry or commerce, but it's also agriculture, natural products, wine, tobacco, fruit. Okay, this definition looks quite old, but you have to remember that the treaty was signed at the end of the 19th century. Another thing to mention is the national treatment. National treatment means that there will be no discrimination between the beneficiaries of the Union. National of any country in the Union shall, of course, as regard to the protection of industrial property, enjoy in all countries of the Union the advantage of their respective law, or may hereafter grant to national. So it means that when a foreigner wants to apply or to implement an industrial property right, there will be no discrimination in any country of the Union. Another point that is important is the priority rights and the priority duration. This is explained in Article 4, which established a right of priority through all the countries of the Union. The duration of the priority right is 12 months for patents. There are a lot of other things inside the Paris Convention regarding the patent, but this is not the focus of the lesson. I just wanted to share with you a few remarkable points and features about the convention, so I won't go into any further detail. I propose to look to the TRIPS agreement. So TRIPS agreement stands for Trade-Related Aspects of Intellectual Property Rights. It was signed in 1986 at the exact time of the creation of the World Trade Organization. The TRIPS agreement is an annex to the General Agreement on Tariff and Trade. It means that the DNA of the TRIPS agreement is free market and free trade. This is a convention that looks at IP right through the lens of commerce and free trade. You can see that at the introduction of the preamble of the convention, when it is said that the members desire to reduce distortion and impediment to international trade, and that they want to ensure that measures and procedures to enforce intellectual property rights do not themselves become barriers to legitimate trade. The TRIPS agreement is the successor of the Paris Convention. The Paris Convention is frozen since 1979. It will not evolve. Future material modification of the IP rights at the level of international will be done through the TRIPS. The TRIPS agreement harmonizes IP rules all over the world. IP rules or IP is considered in a very broad sense, because it covers copyright, trademarks, geographical indications, industrial design, patents, integrated circuit, and also anti-competitive practices in contractual licenses. I will look with you at the basic set of rules regarding patents. The first thing to look at is Article 2, where it is said that the members shall comply with the Paris Convention. Then we jump to the section 5 of the TRIPS agreement, which relate to patents. First rule in section 5 is that a patent must be granted for all invention. You find this in Article 27, where it is said that patents shall be available for any invention, whether products or process, in all fields of technology. So this is quite a broad understanding of the notion of invention that is applied in all fields of technology. However, the TRIPS agreement provides that countries can exclude a certain number of inventions from the patentability. So member can exclude from patentability. The first type of exclusion that is possible is ordre public and morality. Then the members can also exclude diagnostic, therapeutic, and surgical methods for the treatment of humans and animals, and then also plant and animals. All these exclusions have been implemented in the European Patent Convention. The TRIPS also provide for a common definition of the exclusion rights that are conferred by a patent. You find this in Article 28 under rights conferred. And it is said that a patent shall confer the following existing rights, which is that when the patent is related to a product, the exclusion right will be to prevent third parties from making, which means manufacturing, using, offering for sale, selling, or importing the product. And when the patent relates to a process, the exclusion rights mean using the process, offering for sale, selling, importing the product obtained directly by the process. Then you have Article 30 and Article 31, which are called flexibilities. Flexibilities are a limited number of cases where a country can limit or suspend the enforcement right of the patentee. These cases are, for instance, national emergency, health emergency, non-competitive behavior. This is an important aspect of the TRIPS agreement in the framework that we are discussing in the lesson, which is the accessibility of medicine in the framework of the crisis of the COVID-19. So I will revert to these flexibilities in an additional video a bit later. Then finally, concerning the patents, I would like to mention Article 33, which provides that the minimum duration of
button right is 20 years.